Good evening to all of you. First of all, I would like to extend a warm welcome to all the distinguished guests who have gathered here today to celebrate this Dr. L.M. Singhvi Memorial Lecture. At the outset, let me invite the distinguished guests to begin this evening's program by lighting the lamp. Can I request Dr. Abhishek Manu Singhvi to guide the guests? Thank you very much. Now I call upon Mrs. Kamala Singhvi to come to the stage and present a bouquet of flowers to Honorable Srimati Sumitra Mahajan, Speaker of the Lok Sabha. Now I call upon Ms. Abhilasha Singhvi to present a bouquet of flowers to Honorable Mr. Justice Dipak Misra. Now I request Mr. G.M. Singhvi to present a bouquet of flowers to Mr. Soli Sorabjee. Thank you very much. For those of you who are standing, may I request you to occupy a number of chairs which are available both in this side of the aisle and that side as well. Before we begin this evening's function, I would like to take a moment to share some perspectives about the extraordinary life and contributions of Dr. L.M. Singhvi, who does not need any introduction to this audience. He was a truly outstanding parliamentarian, a scholar par excellence, a prolific writer, and an astute diplomat. One can only wonder how a single individual can excel in so many extraordinary ways. Nearly 15 years ago, the then Prime Minister, Mr. Atal Bihari Vajpayee, at a function to release 3 of his books authored by Dr. Singhvi, poignantly observed, and I quote, "When Dr. Singhvi requested me to release his 3 books, I readily agreed. But today I find myself in a bit of a dilemma, for I started wondering what aspect of his personality or what part of his work can I speak on without risking the complaint of incompleteness and inadequacy. The more I look at Dr. Singhvi's work, the more I get convinced that he is not an individual. He is a living encyclopedia. A parliamentarian, a diplomat, a scholar, a writer, an educationist, a constitutional legal expert, and always an engaging speaker. He is truly many persons combined to one. But the person I like the most is he who is always gentle and smiling and hospitable," unquote. There are many aspects of Dr. Singhvi's personality and contributions that is worth mentioning, but I will deal with a few of them. For those of us who are assembled here, who are part of the larger legal profession, including lawyers and judges and law students and law professors, we can easily remember the historic occasion in which Dr. Singhvi proposed the idea of the celebration of Law Day on 26th November, marking the occasion of the adoption of the Constitution of India. Since, of course, in more recent times, this day has been declared as the Constitution Day, and we will have to recognize the contribution of Dr. L.M. Singhvi for not only giving that idea, but also ensuring that it sees the light of the day. Dr. Singhvi's outstanding contribution in public service has seen many manifestations. We are all familiar with the fact that he indeed coined the word Lokpal and Lok Ayukta. In fact, many years later, it was recognized that his son, Dr. Abhishek Manu Singhvi, chaired the Parliamentary Standing Committee, which indeed produced a report relating to Lokpal. But that was a time when his contributions was quite unique, and we could see the formation of that institution. And in that sense, his contribution to institution building is truly remarkable. Dr. L.M. Singhvi also chaired a committee which ultimately culminated in democratic decentralization reforms in relation to Panchayati Raj institutions. In relation to work of Dr. L.M. Singhvi in the international arena, we are all familiar with the fact that the then Prime Minister Narasimha Rao appointed Dr. Singhvi as High Commissioner to the UK. It is a measure of his reputation and professionalism that he remained in that office till 1997, undisturbed during the brief brief tenures of the next two prime ministers. This made him, after V.K. Krishnamenon, the second longest serving High Commissioner for India in the United Kingdom, 1991 to 97, a record the more remarkable for having overlapped with the terms of 4 Indian prime ministers. In 1993, during his term as High Commissioner, Singhvi spearheaded the Indian delegation to the United Nations Conference on Human Rights in Vienna. As early as 1956, Dr. Singhvi attended the International Legal Science Conference under the auspices of UNESCO in Barcelona, Spain. He was part of the delegation headed by former Chief Justice Patanjali Sastry. He was also working as a consultant to draft the constitutions of Bangladesh, Nepal, and South Africa, and later worked as a UN Special Rapporteur on independence of judiciary. Dr. Singhvi's contributions as a scholar and as somebody who has published widely is less recognized, but something which those of who have studied his work are able to discover. In 1993, he was invited by the University of Cambridge to deliver the Reed Lecture, the topic being his own work, A Tale of Three Cities. Singhvi wrote several books in both English and Hindi. These include A Tale of Three Cities, Jain Temples, and Bharat Aur Hamara Samay, India and Our Times. As a writer, he had a substantial output, and his numerous books are written in a style that can best be termed as simple and accessible. There are a mix of general information on specific topics and of his views on various issues in the books and the work that he has authored. Dr. Singhvi also made significant contributions towards institution building as president of the Indira Gandhi National Center for the Arts. He was also a member of the Permanent Court of Arbitration at The Hague. He was also appointed as a member of the UNESCO's Executive Board for 3 years during 2002 and 2005. In 1993, Dr. Singhvi was awarded the Padma Bhushan by the Government of India and an honorary degree of LLD by the University of Birmingham. The Supreme Court of India held the first Dr. L.M. Singhvi Memorial Lecture on Law, Technology and Society. And all of these contributions has been possible because of a single-minded devotion towards nation building. Dr. Singhvi was elected as an honorary Tagore Law Professor in 1973 in the Calcutta University. He worked for the creation of the ombudsman system in India and coined those words that I mentioned. I would like to take this moment to indeed recognize the celebration of a great soul of India who had made significant contributions to a number of areas. Today we are marking this occasion by this memorial lecture, and now I call upon Dr. Abhishek Manu Singhvi to introduce our distinguished guests. Thank you.
Srimati Sumitra Mahajan, Honorable Speaker, Lok Sabha, Honorable Mr. Justice Dipak Misra, Judge Supreme Court of India, Mr. Soli Sorabjee, former Attorney General for India, Professor Kumar, Vice Chancellor, Jindal University, distinguished former Chief Justices of India, two of them with us, three of them with us, I'm sorry, former judges of the Supreme Court, distinguished judges sitting and retired, distinguished members of the legal fraternity, ladies and gentlemen. I have great pleasure in introducing 3 persons who coincidentally represent or have represented the trinity of governance in our nation. The Honorable Speaker presides over the House of the People, the Supreme Legislature. Justice Misra belongs to, and I might add mischievously, shall soon preside over, the Supreme Judicial Organ. And Mr. Soli Sorabjee, as a former Attorney General, has been an eminent constitutional representative of the executive. Among the many distinctions of Thai, as she is affectionately known to many, is that she is the only lady to have been elected to the Lok Sabha 8 times from the same constituency, and I might add, from the same party. That's an important qualification. In these days, loyalty and consistency compete with the 10th schedule fairly strongly. In fact, in the not too small list of 31 Lok Sabha members who have had 8, 9 or 10, Vajpayee ji had 10 terms, she is the only woman amongst 31 persons. In these days of highly divisive politics, and if I might add, the politics of pelf, power, privilege and pomposity, Srimati Sumitra Mahajan's overriding and endearing characteristic is that of simplicity, accompanied by a warmth and accessibility which transcends political boundaries. to have cross-party trust and admiration in these days of trust deficit and narrowness of thought and deed is truly rare, and a quality the late Dr. L.M. Singhvi exemplified and sincerely practiced in all his dealings. Her experience of grassroots and real life is genuine, deep and pragmatic, not only because she's been an 8-time Lok Sabha member, but one who has done the grind from a municipal corporator to a mayor, to a minister of state, and then to a speaker. It is not easy to have such a long career in the messy world of grassroots politics, especially as a woman, and to have yet successfully maintained such a clean, honest, and appealing track record. I noted that unlike Abraham Lincoln, who lost 20 to 22 elections in a row before he won his first and last one as president of the US, Tai has won all her elections. That does not necessarily mean that she has to begin losing to go higher. A bare glance at her curriculum vitae shows that there is hardly a party post of the BJP in Madhya Pradesh or at the center that she has not held. Hardly a parliamentary committee she has not headed or been a part of, and hardly a position in both the legislature and the executive which she has not adorned with distinction. Everywhere she has imparted grace, dignity, and luster to the office. I have always believed that the practice in a convention sense in some countries that no party will put up a candidate in an area from where you expect somebody pre-decided to be a speaker to be elected. That gives great moral strength to the speaker's office. We don't have that convention in India. England has it in a loose sense. But it's a great tribute to her that if there is one person for whom all political parties would gladly leave Indore uncontested, it is for her alone and perhaps no one else. Justice Mishra's judicial career, coincidentally, has had much more to do with the Speaker's home state than his own, since he has spent 12 out of the 15 years as a High Court judge at Jabalpur. He is a man of many parts, a man as much of literature as of the law, a man as much of Sanskrit as of Odia and English. But above all, he is a person blessed with a remarkable convergence of both talent and temperament, which, along with ideology, which in the case of a judge should be less manifest, has been described as the true formula for success and happiness. When I first appeared before him many decades ago at Jabalpur High Court, I was struck by his intellectual curiosity, an inquisitiveness that occasionally transcended the boundaries of the immediate case before him, but always found expression somewhere in the judgment. In that case, he successfully, adroitly, and with consummate ease, distinguished a 5-judge constitution bench of the Supreme Court to deliver what is widely believed to be the correct verdict. His tryst with free speech issues must be much older, since he is a man who revels in jurisprudential aspects of even seemingly mundane and routine cases. But he happens to be the person who has had a trilogy, 2 delivered and 1 reserved, on 19-1A. 2 of them had seminal judgments delivered, the so-called Mahatma Gandhi poem case, definitively delineating the boundaries of free speech, qua the criminal offense of obscenity, and the Subramaniam Swamy case, where I had the privilege to assist the bench, upholding the constitutional validity of criminal defamation, but exploring in depth the intersections and crossroads of free speech. Both judgments are replete with Justice Mishra's deep and abiding knowledge of literature and law, and contain a treasure of poetry, quotations, and historical allusions. Doubtless this arises from his diverse interests, including as author, I noticed, of 4 anthologies of poems in Odia, 2 of which do a psychoanalytical study of Mahabharat's Karna and Ashwathama. The 3rd judgment on the issue whether criminal defamation lies solely for criticism of state government policies and decisions is reserved and is awaited with anticipation by students of jurisprudence, since Justice Mishra has also studied in some depth Western philosophers, including Socrates, Kant, and Nietzsche. In a sense, explorations of free speech, his explorations are more comprehensive because he's even done a short stint as a erstwhile member of the Regional Film Censor Board. He has handled skillfully every branch of the law he has touched. He wrote for the Constitution Bench in Manoj Narula on whether ministers with criminal charges framed can be nominated. He struck down bylaws in Charu Khurana's case, not allowing women to work as makeup artists. He commuted death sentence to life in Ajay Kumar because of 3 years delay in deciding the mercy petition. He wrote a concurrence in the recent Constitution Bench on Arunachal Pradesh, and so on and so forth. All his judgments reflect his erudition and his genuine interest as a student of law, explorer of law. Turning from talent to temperament, I think it is a universal view in the apex court that he is both the eternal consensus seeker and also the most consummate diffuser of tension in the court, always diverting heat, shedding light, and leaving all in good cheer. He has the quality of being genuinely treated as their own by high courts as diverse and different as Odisha, Madhya Pradesh, Delhi, and Patna. He's traveled all across India, 2 of which courts he has presided over as Chief Justice, Patna and Delhi. In these fractious days of judicial and bar politics, Justice Misra's navigation has been faultless. As we all know, for Justice Misra, the best is yet to come. Soli Sorabjee, who has been India's former Attorney General twice, India's former Attorney General, who has been Attorney General twice earlier, needs no introduction to an audience, especially at the India International Center, where he has shared several wonderful moments with Dr. L.M. Singhvi. Soli has many passions, but 3 of his animating ones are free speech issues, human rights issues, and jazz. He has written prolifically on all 3, both in articles and in book length. But he does a disservice to the nation by not writing, and in book length, by not writing something in the nature of memoirs, despite my several importunings to him, since he has been a witness to an era, and his view on people, periods, and events would be most interesting and informative. Soli has steered many institutions, including this precious one, through turbulent times, ably, and in that sense, carried forward successfully the vision and wishes of his predecessors, including Kamala Devi Chattopadhyay and Dr. L.M. Singhvi. I don't know how many of you are aware of his superlative mimicking powers, and also his sense of fun and puncturing of pomposity. You have heard Vice Chancellor Professor Rajkumar at some length on the person to whose memory this lecture is dedicated, that is Dr. L.M. Singhvi. But I cannot resist quoting to you 2 short parts of what Gopal Krishna Gandhi, scholar, ambassador, governor, true Gandhian, and above all, writer extraordinaire, wrote about Dr. L.M. Singhvi in an article which he titled India's Vibgyor Man. And I quote, "Those who knew Dr. Singhvi well knew that he was no color change, only very fond of the rainbow. Dr. Singhvi had, in terms of political colors, no single color. There used to be, in my childhood days, before quality stormed the ice cream world, an ice cream called Vibgyor, an acronym for the rainbow's 7 colors. Dr. Singhvi was a Vibgyor mind and a Vibgyor temperament. He felt genuinely and strongly that all the colors of Indian politics had a claim to our chromatic appreciation." And he goes on to say, "A jurist and lawyer by training, an aesthete by instinct, a scholar by sheer application, a parliamentarian by careful design, and a diplomat by courtesy of good circumstances, Dr. L.M. Singhvi could influence, persuade, cajole, argue, or just overwhelm the person he was talking to by a cataract of well-meant and well-chosen words," unquote. We are very deeply obliged to have you all here, and we look forward to addresses from the speaker and, of course, the person who's delivering the memorial lecture today, Justice Misra.
Call upon Mr. Soli Sorabjee, former Attorney General of India, to deliver the welcome address.
Of course. So high. Lots and lots of it.
Honorable Savita Mahajan, Speaker of the Lok Sabha, Honorable Justice Dipak Misra, Judge Supreme Court, Professor Rajkumar, Dr. Abhishek Singhvi, sitting and retired judges of the Supreme Court and High Court, Justice Bhandari, Judge of the International Court of Justice, friends and admirers of L.M. Singhvi. L.M., as we popularly called him, was a man of many parts, was a resplendent personality. First, he was a lawyer whose persuasive skill usually made him obtain a favorable order for his client. But as a lawyer, he was very kind to his opposing juniors. He praised them even though they didn't deserve the praise. But that was L.M. Singhvi. Then he was a linguist who spoke brilliantly, both in Hindi and English. He was a statesman who as High Commissioner of India in the UK, enhanced the image of our country. And above all, he was a life trustee of the IRC, which is above everything else. Good nature and good-heartedness were in his DNA. He shunned pomp and formality and mixed very pleasantly with people. I'll give one example when he completely surprised me. I was supposed to meet him at the High Commission on a particular day at a particular time. But lo and behold, he came to the flat and someone said, "Saab, High Commissioner." Kaun? High Commissioner? Acha, acha, acha. I was in my pajamas, so he came up. We talked. But the point I want to make is complete informality. And that is what I liked about LM. And we got on so well in every field in which we interacted or cooperated. He planted many trees, in England. Isn't it? He planted quite a few trees in England, where sometimes do criticism of the UK press. But he went on unfazed. And I'm very grateful to him because it was because of his persuasion that I agreed to become a trustee of the IIC, and that is what accounts for my presence here. Well, you know all about LM, but as I said, the real thing is this good-heartedness and good nature were in his DNA, and that is what we admire him above everything else. Thank you.
Thank you very much, Mr. Sorabjee, for those words. Now I call upon Honorable Mr. Justice Dipak Misra, Judge, Supreme Court of India, to deliver the 5th Annual Dr. L.M. Singhvi Memorial Lecture.
Srimati Sumitra Mahajan, Honorable Speaker of Lok Sabha and Chief Guest of today's function, Mr. Soli Sorabjee, Senior Advocate and former Attorney General for India, Dr. Abhishek Singhvi, Member of Parliament and Senior Advocate, Chief Justice Ahmadi, Chief Justice Lahoti, Chief Justice Lodha, Justice Chauhan, Justice Singhvi, former judges of the High Court, Justice Nandrajog from High Court of Delhi, senior members of the bar, friends from electronic and print media, ladies and gentlemen. Justice Singhvi, Mr. Singhvi, while introducing me, said, I am read from Socrates to Nietzsche. We can't leave it at that. Nietzsche once wrote a snake that cannot cast its skin cannot live. Similarly, a mind that is prevented from changing its opinion ceases to be a mind. Forget the progression. Nietzsche is a hated philosopher, but sometimes people revere him. And these golden words of Nietzsche is of not less importance than what Voltaire wrote about agreement and discord. Dr. Singhvi told me I have to have a written text. I said, I will take it. And I have. I read it. Fundamentally, I am a extempore speaker, not a pro tanto speaker. There's a difference. After death of Sir Winston Churchill, his son was asked a question. What kind of speeches of Sir Winston you value the most? His son said, his extempore speeches, but not written speeches. And I'm not saying that about his London slave speech, but I'm saying something what he immediately retorted while he was not the Prime Minister in early 40s. A delegation was sent to USSR, the undivided one and the powerful one, to learn and talk about socialism. The two representatives who headed the delegation were George Bernard Shaw and the Lady Astor, the first lady to the House of Commons. When Churchill was asked, Sir Winston, how do you feel about this delegation or the people who head the delegation? Winston said, you know, there are two persons, George Bernard Shaw and Lady Astor together, have been rightly chosen to go to USSR because Russians love circus. So coming back to my restriction on this written text. Dr. Singhvi, after obtaining my consent to deliver Dr. L.M. Singhvi Memorial Lecture, has sent the lectures delivered by eminent jurists, judges, thinkers, and philosophers. That apart, I also found the communication contained the tributes given by many to late Dr. L.M. Singhvi and the kind of books authored by the great multifaceted personality. I'm obliged to refer to some of the tributes to prove a point. In one tribute, one speaks of him as a man who welcomed ideas, breathed fresh air of intellect, and splendidly adjusted every moment to the various roles he played in his life. Another likes him to walk with Chagla and Palkiwala and points out the commonality between them was they thought for, spoke, and worked for Republic of India. Yet another, in his inimitable style, would confer him the stamp of excellence and innovation and put him in the space of epitome of man that is glorified in Hamlet by Shakespeare when he says, what a piece of work is man. How infinity, in faculty, in action, how like an angel, in apprehension, how like a god. There is a tribute which would reflect on his diversified aspects of life, that is literature, diplomatic brilliance, ability and commitment in handling public affairs with command and interfaith movement. With all the humility at my command, what I have read about Dr. L.M. Singhvi and heard him once when he came to Cuttack to address a seminar while he was the High Commissioner of India to the United Kingdom. And my brief interaction with him as a young lawyer is that he was a rainbow of intellect, an embodiment of individual dignity, what strived for collective good. He eloquently spoke about the great traditions of this country and firmly believed and acted for independence of judiciary. I'm extremely honored, in a way humbled, and simultaneously delighted to be invited to deliver the 5th annual memorial lecture. The Indian justice system is reflective of majestic legal order. It has a history that excites one to travel to the Vedic era. Reflection on the past has its relevance as it connects us to our past, especially the cultural foundation. We continue to harness such archived, not archaic, principles in resolving issues concerning law and culture to prevent a conflict between the straitjacket principles of law and the traditional cultural values in society. The Mimamsa rules of interpretation, which are a part of great intellectual treasury and asset, were used in the case of Vijayanaran Thate and Gujarat Urja Vikas Nigam Limited and many others. Undeniably, we have traveled far in the pursuit of conceptualizing the true import of dharma and facets of justice for a coherent social order. The present form of the Indian justice system receives a constant gravitational pull from our organic and compassionate constitution. The constitution of this country remains the foundation text of the post-independent Indian justice system, and the constitution has undergone substantial amendments in order to upkeep with the emerging legal necessities of a dynamic society to fulfill the aim and ambition of the collective. The Supreme Court has been responsive to the changes in the Indian society by employing the tools of interpretation. This has been largely done by expanding the meaning of constitution in favor of a different segments, especially the poor and the marginalized sections of the society. This approach of Indian judiciary gradually became its reflection of a progressive judicial institution. Progressive thinking, recently I read a book, The Upside Thinking. Actually, how does one think? Let's have I can't go on reading. Huh? How does one think? What neurons are reflective of his thinking? He is an economist, but goes to psychology and got a Nobel Prize. He talks about instinctive statistics, instinctual statistics. When I talked to someone who has studied economics, he could not explain to me. I read the book. Despite my best efforts, I could understand the sum. That statistics can be in the realm of instinct. You don't have to apply your intellectual brain, or intelligent brain, or emotional brain, or any other facets of the brain, but instinctual brain. So progressive thinking has its denotative as well as connotative expanse. Coming back to the line, progressive thinking outlines what we believe as progressives and how we view the world. It is designed to help our nation's diverse, progressive community and articulate a common philosophical paradigm to a wider public. It's with these conceptual foundations and fashioning of innovative instruments by the process of interpretation, the court has broadened the area and arena of human rights. The Indian judiciary has not confined its shielding umbrella to its citizens only, but has offered the constitutional protection of life and liberty to non-citizens as well. In Khudiram Chakma case, the court has held the protection of Article 14 and Article 21 encompasses extraterrestrials within its purview. The court restrained the forcible expulsion of Chakma refugees from the state and direct the state governments to ensure that the Chakma situated in its territory are not ousted by coercive action, but in accordance with law. This decision has its own significance, for India is not a party, or was not a party at that time, to the International Convention on the Status of Refugees. Expanding the connotative horizon of Article 21, the court has presented the progressive thought process in many cases. But let me refer to the recent case which has been filed under the by NALSA, taking recourse to social interest litigation. A distinction has been drawn recently between public interest litigation and the social interest litigation. The transgenders have been fighting for their identity. Man, philosophically, economically, socially, emotionally, is in search of an identity. That is why Jean-Paul Sartre says, you are condemned to be free. A devastating statement. Man is condemned to be free, whereas our scholars, our ancestors do not call it that you are condemned to be free. If you have come to the surface of the earth by leaving your home, because anandat sanjataha, you have been created by the bliss and pleasure of God. So this identity is not only a constitutional problem, but a social and other problems. That is why the court recognized the concept of grievance, of identity of the transgenders, and spoke regarding her to the contour of human dignity. It says, democracy requires us to respect and develop the free spirit of human, which is responsible for all progress in human history. Democracy is also a method by which we attempt to raise the living standard of the people and give opportunities to every person to develop his or her personality. It's founded on peaceful coexistence and cooperative living. If democracy is based on the recognition of the individuality and dignity of a man, a fortiori, we have to recognize the right of a human being to choose his sex, gender identity, which is integral to his or her personality and is one of the most basic aspects of self-determination, dignity, and freedom. Then the court evolves a theory, the growing recognition that the true measurement of development of a nation is not economic growth, but it is human dignity, of which Mr. Soli Sorabjee is quite fond of. The preamble of our Constitution emphasizes on individual dignity and fraternity. Developing the said two concepts in Subramaniam Swamy, I know there is criticism, but the concepts are concepts. You can't deny individuality, you can't deny constitutional fraternity, and you cannot deny dignity. Application may be wrong somewhere. The court says, fraternity as a concept is characteristically different from other constitutional goals. It as a constitutional concept has a keen bond of sorority with other concept, and hence it must be understood in the breed of homogeneity in a positive sense and not to trample dissent and diversity. It is neither isolated nor lonely. The idea of fraternity is recognized as a constitutional norm and a precept. It is a constitutional value that is required to be sustained and nourished. You see, there are two schools of thought. One is individual liberalization, the other is collective protection. In this decision, the court doesn't say you do not have a right to censure, you do not have a right to disagree, you do not have a right to criticize. Yes, you have all the right, but do not offend. The other man feels offended, doesn't matter. You should not offend by your speech, articulation, language, writing. Fault finding and disagreement is required even when it leads to an individual disquiet or group disquietude. Collective ethics cannot govern free speech. That's the sentence used in this judgment. These judgments are testimony of the fact that interpretation is a vehicle for progressive orientation. No legal system in the world can mature on its own with merely passing of the laws by legislative bodies or mere textual or formalist interpretation of its text by the courts. There has to be a structural and purposive construction. The court has become conscious of this vibrant sound because when there is a sound outside of development, no court, no constitutional court can become alien to that concept. It has to echo that sound, love that echo, and respond. And the Supreme Court of India responds. You see, the whole problem in this country is we do not respect each other's dignity. The tributes that have been written about Dr. L.M. Singhvi, and for which I presume you have assembled here, centers around dignity, collaboration, amiability, cultural reciprocation, and many facets. That is why, apart from my main theme, which I'll develop within no time, the court talking about dignity and honor killing. You see, we talk about gender justice. There was a warning. It has to be understood in the proper sense. But in honor killing, the court says, and the dignity context, one may feel my honor is my life, but that does not mean sustaining one's honor at the cost of another. This is from Vikas Jadhav. Freedom, independence, constitutional identity, individual choice, and thought of a woman, be a wife or sister or daughter or mother, cannot be allowed to be curtailed, definitely not by application of physical force or threat or mental cruelty in the name of self-assumed honor. That apart, neither the family members nor the members of the collective has any right to assault the boy chosen by the girl. Her individual choice is her self-respect, and creating dent in it is destroying her honor. And to impose so-called brotherly or fatherly honor or class honor, actually we are now suffering from the imposition of class honor by eliminating her choice in a crime of extreme brutality. So when it is done under a guise of honor, it's a vice, condemnable and deplorable perception of honor comparable to medieval obsessive assertions. May I pause here for a while? I really and truly believe in literature. We are taught to believe. we are taught to have faith. I still feel pain at the age of 64 about the death of Christopher Marlowe. Marlowe died at age of 29 because he was invited to a duel, and the gentleman, drunk as he was, a great man, a great writer, he accepted the challenge and ultimately was killed. Recently, some researchers have found out he has co-authored some of the books with William Shakespeare. We have been reading that in theory since 70s, and this 2016 it has proved, because that was obsession with medieval honor. Making the legal study tool dynamic in character, the judiciary has borrowed intellect from the non-legal disciplines in interpreting critical legal issues, especially in the matters relating to science and technology, society-oriented issues concerning law and religion. Flexibility is the norm of interpretation of constitutional ethos that has been introduced in the sphere of new emerging situations, and the duty of the court is to adopt the law to suit the changing needs of the time. This very principle has been expressed by a famous American jurist, Ronald Dworkin, by saying that we must draw a distinction between a concept and conception. The concept may remain constant, but the conception must change according to the needs of the time. For example, cruel and inhuman punishment is a concept, but its conception can keep changing with the changing time. The examination of the implications of courts' innovations for environmental jurisprudence reveals that the application of innovative methods to resolve environmental disputes and implement court orders is certainly different from the usual adjudicatory functions of the court. While the procedural innovations, such as public interest litigation, have widened the scope for environmental justice through recognition of citizens' rights to healthy environment, by substantive innovations have redefined the role of court in the decision-making process through application of environmental principles of expanding the scope of environmental jurisprudence. In resolving more than 100 environmental cases since 1980, the court has continuously engaged itself in the management and resolution of the environmental conflicts, and thereby increased the country's dependence on the court for environmental protection. We have an intellectual propertyism through IP laws enacted beyond traditional intellectual property of patents, copyrights, trademarks. Some of these include intellectual property protection to geographical indications, plant varieties, farmers' rights, semiconductor integrated circuits layout designs, biological diversity, and protection of seeds. The court has enhanced its safety, security, and stability further by the doctrines enumerated in the umbrella of fundamental rights. These are rights that are intrinsic to or necessarily flow from fundamental rights in the Constitution. This has come in due to application of techniques for a life having respect of human life. The Novartis case presented the court with an opportunity to lay down the law on several fundamental aspects of the Act: relationship between invention and patentability. This court also had the occasion to deal with the law on disclosure and anticipation, position on incremental innovations, and working of patented inventions. We have an issue with regard to privacy. I'm not concerned what has been referred to a larger bench, but privacy is a concern, and it has a different realm altogether. The privacy concerns have been plaguing the citizens across the world. It becomes increasingly important to address the same so as to give individuals control over their personal information and opportunity to give an informed consent for the use of the same. The right to privacy is not constitutionally protected right, but judicially interpreted and derivative fundamental right. In R. Rajgopal, it has been ruled that a citizen has the right, even the right to be left alone, to safeguard the privacy of his own, the family, marriage, procreation, child earning, and education, among others, and that nothing concerning this could be published without consent, except if a person voluntarily throws himself into a controversy or any of these matters becomes a part of public records. That is why the English saying, "My home is my castle." It's not that the man thinks the home is castle. I am the king of my privacy. I am the emperor of my privacy. O crown, don't you dare enter into my privacy. That's the, you see, there are 10 meanings of this sentence, but I can't tell you the all 10 meanings, but it basically emphasizes the love, the adoration, the possessive instinct of an Englishman to have his own privacy. There's another concept in English. They say if a thief comes to rob you and you are helpless, or you are a man thin like me, as not strong as whoever he is, you just have to say, it's not fair. It's not fair. You can't, it's not fair. I'm talking about last century. Once you say it's not fair, he will not steal anything from you. He says, fine, you are left by a thief. That's the philosophy of privacy. Dr. Singhvi, while introducing Mr. Soli Sorabjee, has told about his love, adoration for free speech. He argued this matter, and I'm obliged to refer to it for a different reason. The year 2015 was very significant for the development of cyber law in India, when the court in Shreyas Singhal, while upholding freedom of speech and expression, struck down Section 16A of IT Act. Section 66A defined the punishment for sending offensive messages through a computer or any other communicative device like a mobile phone or tablet or a conviction, and the act can fetch a conviction for 3 years of jail and a fine. Over the last couple of years, there had been many cases in which police has arrested the broadcasting of any information through a computer, resource, or a communication device which was grossly offensive or menacing in character, or which, among other things, as much as caused annoyance, inconvenience, or obstruction. The court has now declared that Section 66A is not only vague and arbitrary, but disproportionately inverts the right of free speech. I must make it clear that decision does not deal with obscenity and defamation, and rightly. The ongoing decade has witnessed India as an arbitration-friendly destination. In Balco, it has set the tone for India to compete globally in boasting as the destination of practicing greater judicial deference towards foreign-seated arbitration, and also this case declared Indian arbitration law to be seat-centric. In the year 2003, the judiciary paved the way for referring non-signatories to an arbitration agreement to settle disputes through arbitration in control. The court held that the expression person claiming arbitration through or under, as provided under Section 45 of the Act, would mean and include within its ambit multiple and multi-party agreements. This judgment has a far-reaching positive effect, especially in the cases of international commercial arbitrations. This is being still debated involving composite transactions and multiple parties. The court has also narrowed down the scope of public policy close to adopt the modern legal requirements, and further the court has eased the arbitrability of cases involving allegations of fraud for referring such matters and parties to foreign state arbitrations. The trend of such pro-arbitration judgments delivered by the Indian judiciary is on the rise, and the court is constantly stabilizing the global normative test and best practices of international commercial arbitration in India. The other day there was the inauguration ceremony of the ICDR, the opening of the venue, and there the question arose with regard to whether the intervention of the court is that extent so that the India is not able to become an hub of arbitration. There was different reactions. My perception is it's the litigant sometimes who wants to come in every issue. The courts refuse, but takes time, maybe a month, maybe two, as they argue. But still, I think with the passage of time, India is going to be the arbitration hub for certain quality of arbitration in the world. Now, I'm having a different approach now. You see, from the inception of the Supreme Court, marking the celebrated speech of the first Attorney General, M.C. Shitalbad, the jurisprudence has developed, but the development of jurisprudence can be divided into certain eras or spheres or yugas. The development of jurisprudence can be divided into different eras. In the first 15 years, the court was quite conservative. Thereafter, there was the era which concentrated on rights, the right-oriented approach, but the interpreted process was not that progressive. It saved the fundamental rights to a great extent. In the 70s, the court played a balancing role, and the concept of federal structure, as is understood in the Indian context, was maintained. However, in ADM Jabalpur, the court held that no one can approach the court to enforce their rights during emergency, and that judgment, let it be said without any kind of inhibition or reservation, corroded the balance. That decision, however, in the ultimate eventuate, constrained the court to redeem itself, and in the transformed role, the court changed its perception and took a pro-poor and pro-right stand. The post-emergency era and 1980s witnessed numerous cases which involved progressive intervention. The epistolary facet evolved around mostly social action litigation in India. Professor Upendra Bakshi remarks that in 1980s, Supreme Court of India became Supreme Court for Indians. Justice Bhagwati and Justice Krishna Iyer recognized the possibility of access to justice to the marginalized people through PILs going beyond the conventional concept of locus standi and enforcing social justice. The social justice became the norm, and it was really expanded. The socio-economic needs of marginalized groups were treated as integral to the fundamental right to life under Article 21 of the Constitution. The court started creating new rights, new guarantees, and picking up from Article 14, Article 19, and Article 21, the Golden Triangle, which and also at the same time involved the concept of environmental purity. What you call environmental purity, individually, I would like to call it environmental morality. The collective must have environmental purity, and the individual must have environmental morality. A progressive interpretation of the court has widened the right of free expression. I've referred to Rangarajan again for simple reason that goes and extends the right, and Khushbu extends the further right. The Khushbu's author is here. Now let us come to the boundaries that was crossed appropriately and in accordance with law. The jurisprudence relating to voting rights or the election rights. You see why the free expression, the free speech right under Article 19(1)(a) was read conjointly with the voting rights in a differently manner. Right to know. I have a right to know. I am a citizen of this country. I am going to vote. I have a right to know. The concept of free expression extended the boundary in PUCL, where the court held that right to speech and expression under Article 19(1)(a) is in play when voter gets to cast his or her vote. In order to make that exercise of right meaningful, the voter should be held entitled to know certain qualification of the candidates concerned. This ruling of the court connects right to speech and expression with the democratic political process of election, is pregnant with many possibilities. It can be read in the light of other provisions of the Constitution as providing for right of political participation. The political participation is partly done by exercising the rights of free speech, assembly, and association. The next era of the court witnessed a slight rethinking in its pro-poor perception, especially relating to regularization, and then came certain authorities which said there has to be corporate growth as well as individual growth. The synthesis sought this backdoor entry should be stopped. Whatever it is, there was a shift, there was a perceptual shift. They wanted to save, the court wanted to save the right of equality and also the right provided under Article 14 and the growth of the country, which was slightly on a scale at that time. You see, gender justice has been a problem every day, you hear everywhere. You see, Charu Khurana case, Dr. Singhvi has referred, it's very peculiar. We say Bollywood, that's Mumbai. We say Tollywood, that's Tollygunj in Calcutta. Hollywood, that's in Orissa. But to be very frank with you, despite my being a member of the Regional Film Censor Board for 3 years from 91 to 94, I did not know that this kind of a discrimination did exist. When the case came before us for the first time, we noted that the women artists were not allowed to be makeup artists, but they can only be given the role of hairdressers. Whatever the court did, eventually the court spoke these lines. I quote only 4. All practices derogatory to the dignity of women are to be denounced. Be it stated, dignity is the quintessential quality of a personality, and a human frame always desires to live in the mansion of dignity, for it is a highly cherished value. Then came the Stridhan. You see, what is happening, whenever a woman files a case under the Domestic Violence Act, some kind of pleas are taken. In Krishna Bhattacharya, the court said, domestic violence and the locus standi, especially pertaining to Stridhan, is to be expanded. On the ground, it covers a range of violence which takes within its sweep economic abuse. And the word economic abuse, as the provisions would show, has many a facet. It's not really grounded on one aspect. Now I will come down to the present, because there was a suggestion from Dr. Singhvi to christen the topic in a different way. I said, possibly that may not be proper. This will be the appropriate name, to which he agreed. From that we proceed. The progressive vision of the Constitution is nothing but progressive judicial hermeneutics. I must explain the story about Hermes. Hermeneutics is a word which means science of interpretation. You see, who is Hermes? Like we have Narad. Narad is a man who used to interpret the language of the god to the man, but people say that was a quarrelsome man. But that is not that way. Hermes is the Greek god who was a messenger between the god and the man, because the man was not able to understand the language of the god, and therefore the Hermes was interpreting the language of the god to man. And thereafter in science, in political science, in philosophy, and in law, hermeneutics have been used to understand the science of an art of interpretation, and that is why I've said progressive judicial hermeneutics. Here comes a pregnant, but definitely a significant one, that the but. There is still the need to bring further change in the orientation of judiciary to bring about social reform and contribute to good governance. As per the United Nations Commission on Human Rights, the key attributes of good governance include transparency, responsibility, accountability, participation, and responsiveness to the needs of the people. This is thus linked to an enabling environment conducive to the enjoyment of human rights and promoting growth and sustainable human development. The change in the orientation of judiciary has to be guided by the constitutional vision of justice embodied in our Constitution. The doctrine of equitable access to opportunities for growth, affording participation and capacity to influence in the decision-making in public affairs has to have priority. There is a need to ensure a responsive judicial system which dispenses justice in a meaningful manner, and it ensures the protection of rights by upholding the rule of law. Though the passage is an abstraction, I think anyone who is listening here, there are more learned people than I, can translate into the concrete terms. For improvement of the Indian justice system, there is need for reorienting the attitude of the bar. The court system is alien to the common man in society. This may be attributed to the formal adversarial system we follow, or to the structured court process, mostly in a language not understood by the common man in society. The reverence and faith of the public in the judge and the justice delivery system is essential to maintain the sanctity and in turn strengthen the judiciary, which is the last bastion of public reliance. Here lawyers play an important role in portraying the right image of the judiciary. The common man who visits the court forms an impression about the legal system and its functioning from his lawyer, who in a way introduces him to the system and its functioning, and helps him to form an impression about the structure, about the people, and about the institution. The lawyer, as an officer of the court, has the duty to instruct and educate his client about the justice delivery system. The lawyer plays the crucial role of upholding the majesty of justice, which in turn is so crucial for strengthening the judiciary, as the strength of the judiciary lies in the orders being respected and executed. Lawyers to remind and reorient themselves to the role expected of them. Here it would be essential to remind ourselves that it's only an ethical bar that can set standards and check faults in the justice system. From this, the bar has to instill its members ethics of honest practice of law. Let's pause here for a while. Recently, I read in a newspaper in UP there are 100-day strikes. Who goes on strike? It's the lawyers. Whatever the reason. That cannot be justified. We can't have a thought for progression of justice and 100-day strike, whichever the state it is. Please do not take it to heart. I want to blame the lawyers. I also take the blame on myself. I'll go to the next passage. There is also the need for judges to reorient their way of functioning and change their attitude to involve the common man as a litigant who appears before him. The judges today need to work towards removing the alienation the common man feels by changing their attitude and considering themselves as the representative of an institution that dedicates itself to the serviceability and work for the satisfaction of the people who come to the court. Judges have to understand that they have a social responsibility to ensure effective and efficient justice, assure legal aid to the poor, bring transparency in judicial affairs, take active and continuous interest in the economic, social welfare of society through dispensation of justice. Now, I must remind you, the serviceability of the institution I am not using, neither the Supreme Court is using for the first time. It has been used in the Bhopal gas tragedy case. The justice system is respected only if it continues to make itself relevant and regains the faith of people in its efficiency. The judicial administration has to revamp itself with times to increase its capabilities. It doesn't help to deny that there is no need for re-engineering the process by optimizing the use of its human resources and bring about change management by harnessing the potentiality of the available information and the communication technology to its fullest extent to enhance judicial productivity both qualitatively and quantitatively, as also make the justice delivery system affordable, accessible, cost-effective, transparent, and accountable. There is need for further informatization in the administrative and management process of courts to usher in transparency. The application of video conferencing facility from the court to the prison where the under trials are housed has to be enhanced to make care of many delayed trials. Video conferencing service will not only help in avoiding unnecessary adjournment of cases, but also would be cost effective. Another effective measure can be the use of technology to collect information like the timeline of a case from time to time it was instituted in a court of law to the final stages of appeal. A judiciary grounded on ethics is essential if the courts are to fulfill fulfilling the task of upholding the rule of law. Judicial ethics enables a judge to act impartially, which is the lifeblood of the justice delivery system. It's only the ethical who can develop the habit of closed eyes and open ears, blind toward the party, but open ears to the law. The fundamental value in judicial ethics is impartiality, and where impartiality fails, the trust corrodes. It is to be seen that there is no deficit of trust. The canons of judicial ethics aim at minimizing the effects of judges' political or social views or even philosophical beliefs on the outcome of cases. Constant re-examination of judicial ethics will help ensure over the time the ability of the judiciary to welcome happily public scrutiny. Judicial ethics should reflect the change of societal values issues. There is much room for research and development in the field of judicial ethics. In this context, I may quote an expression from All Warren. Our judges, including me, our judges are not monks or scientists, but participants in the living stream of our national life, seeing the law between the dangers of rigidity on the one hand and of formlessness on the other. Our system faces no theoretical dilemma, but a single continuous problem: how to apply the ever-changing conditions, the never-changing principles of freedom. That is what the judge said for the judges. You see, there is a concept called, which is newly developing. I hope some of you might have read a book called The Proof of Heaven by Ibn Alexander. A man should not, man includes a woman, should not stick to hypnotic rigidity. I am not using the word conservatism, using the word hypnotic rigidity. Whatever your thought, you are supposed to express as long as it's parameters of law. Being stuck with a notion of hypnotic rigidity is a human failure. Now I'm talking about a database for a different reason. I am not on computers. Building up a judicial database like this will enable us to assess the performance of the courts, and this can be used to assess the individual performance of judges. This will go a long way in identifying what the backlog is and what types of cases are clogging the system. By maintaining a good and detailed case database, we can also do things like track old cases, many of which have become meaningless, can be separated and listed for hearing, and the disposal normally will not take much time. Same is true of many interlocutory applications, and all this can be served by database and also assessment of a lawyer who is taking time and a judge who is not functional. It shall be a value-loaded system. The progressive constitutional vision is that of a strong nation deriving its strength from the masses and their shared beliefs of equality, individual freedom, and democracy. It's abundantly clear the fact India is the world's most populous and promising democracy. Apart from being the world's biologically youngest nation, the democratic and participative vision, as far as they are constitutionally permissible, should be welcome. I am reminded Justice Lodhi, as Chief Justice, while addressing, I think, the Bar Association of India, he has come back from the St. Petersburg, and he said, he was in the plenary session, and when he said that I addressed that India is governed by rule of law, they were surprised. I think I am confident about the line he uttered, that yes, the rule of law prevails. Nobody is punished without a trial. There is an absolute rule of law governs in transfer of power. That surprised the Russian nation. This is just an aside. Talking about is basically is the power of the masses and power of the belief. The values that any system needs to cherish for progressively orienting itself, now let's come back to philosophy, are hope, engagement, and empathy. Hope to emerge better on embracing this concept, engagement with its key target beneficiaries, and finally, empathy, without which true justice cannot flow. While holding these values in an exalted position, it's crucial to note that the concept of progressive orientation, whether with respect to an individual or a system, comprises of 4 essential dimensions, each of which must be paid due attention so that the whole turns out greater than the sum of its part. You see, this is a different philosophy. The whole turns out greater than sum of the parts. He is not talking about divinity. Your divinity remains the whole in the whole and whole in the part. That is why the scriptures say, Punna madaha, punna midang, punnat punna, mudachyate, punnasya punnamadaya, punnameva vasishyate. Even if you take out the punna from punna, punna remains, but that's not the concept in this case. These dimensions are physical, mental, spiritual, social, emotional dimensions. The Indian justice system is like a house with these 4 rooms which constantly require healthy ventilation. Just like a body needs exercise, nutrition, and stress management in the context of judicial system, this should translate to the court's physical infrastructure, caring effectively for the physical body of the system by supplying it with the right nutrition, that is, focusing on organizational framework and performance of underlying metrics, or performance metrics. These attitudes will ensure endurance and flexibility for the purpose of stretching the system in tune with first building needs to accommodate the diverse concerns. The mental dimension in Indian justice system would entail the need to have constant legal education, be them judges, lawyers, court officials, polish their crude edges in an endeavor to ensure faster, better justice, evolving to fit in the new concerns of a fast-changing society. The emotional dimension would involve working with a sense of service, energy, synergy, and with confidence of intrinsic security. The Indian justice system, in order to achieve progressive orientation under this dimension, must function bearing in mind who it is serving to. It works to provide justice not to just the world's largest democratic population, but also a very diverse population based with vastly different and ever-changing conceptions of justice, based on their economic and social segments. Hence the need for empathy and a sense of duty. The spiritual dimension focuses on value clarification and commitment. This element may be said to comprise the core in terms of importance, as it embodies the justice system's commitment to certain central constitutional values, those which must always be borne in mind while delivering judgments. In the context of legal professionals, these values could be well summarized by, to Judge Albert Parry's 7 lamps of advocacy, namely honesty, courage, industry, wit, eloquence, discretion, and fellowship. Now, how do I end? Adoption of an integrated and balanced approach, having due regard to the concept of progressive orientation and staying true to the values of hope, engagement, and empathy, will help the Indian justice system to go a long way in ensuring justice is delivered to everyone who approaches it. In this context, I quote a few lines from the poem Justice by Rudyard Kipling. Kipling is quite well known in India. Before we lose the word that bids new worlds to birth, needs must we loosen fast the sword of justice upon earth, or else all else is vain. I repeat, of justice upon earth, or else all else is vain. Since life on earth began, and the spent world sinks back again, hopeless of God and man. Kipling said, not I. Now, 2 adieux. You see, Chamberlain was a peculiar speaker. I don't compare myself with Chamberlain, I don't need to. Chamberlain, while addressing an audience while coming to an end, he said, ladies and gentlemen, I am not happy. You see, if Chamberlain is not happy, he's not happy. How does the audience bother? But somebody stood up. Mr. Chamberlain, why are you not happy? He said, young man, but he was young. Now I have to say differently. Young man, I am not happy, but I am delighted by your benevolent presence. So I echo that feeling and part. Thank you. Thank you very much.
Thank you very much, Honorable Mr. Justice Dipak Misra, for this really inspiring and comprehensive tour de force on the history and evolution of Indian civilizational heritage, jurisprudence, as well as political theory, and also contemporary importance of access to justice. So I'm really grateful to you for that comprehensive lecture. I can only say that you spoke like Professor Misra, and I am indeed grateful for you to have spoken with intellectual rigor and erudition in relation to this topic. Now I have great pleasure in inviting Honorable Srimati Sumitra Mahajan, the Speaker of the Lok Sabha, to deliver her Chief Guest Address.
मंच पर विराजमान उच्चतम न्यायालय के न्यायाधीश माननीय न्यायमूर्ति दीपक मिश्रा जी, राज्यसभा के हमारे माननीय सदस्य डॉक्टर अभिषेक मनु सिंघवी जी, माननीय सोली सोराबजी जी, और यहाँ पर कई सारे ऐसे पूर्व भी न्यायाधीश, आज के न्यायाधीश, या मैं ये कहूँगी कि लॉ के संदर्भित बिग बॉसेस ऑल्सो दे आर प्रेजेंट हियर, और ऐसे भी गणमान्य हैं जो डॉक्टर एल.एम. सिंघवी से कहीं ना कहीं प्रेम रखते हैं, नाता रखते हैं। आज का ये वास्तव में कार्यक्रम ऐसा है कि मेरे लिए कई बार समस्या भी होते हैं, क्योंकि जब स्पीकर की कुर्सी पर बैठ गई तो ये होती है, मैं लोगों को सबको कहती हूँ, पार्लियामेंट मेंबर्स को कहती हूँ, यस वी मस्ट हैव डिबेट, डिस्कस, you decide something, I am there to preside. इतनी बात बोलती हूँ क्योंकि मुझे उतना ही करना है। लेकिन आज यहाँ पर ये भी सोचा कि हमारे न्यायमूर्ति जी के मुँह से कुछ महत्वपूर्ण बात भी सुनने मिलेगी। दूसरी एक बात यहाँ आने के पीछे ये भी थी कि डॉक्टर अभिषेक मनु सिंघवी जी सालों से हमारे एल.एम. सिंघवी जी, लक्ष्मीमल जी सिंघवी जी, जिनके साथ मैंने भी कुछ देर काम किया है, और उनकी स्मृति में ये व्याख्यानमाला आयोजित होती है। देखिए, ऐसा योग भी बहुत रेयर होता है कि पिता कर्तृत्ववान हो, पिता कीर्तिवान हो, और उस कीर्तिवान कर्तृत्ववान पिता की संतान भी उतनी सक्षम हो, और उस कर्तृत्ववान पिता की स्मृति में वो कुछ कार्यक्रम करके इस तरीके से उसको चलाए। बहुत कम ऐसा देखने मिलेगा, और इसलिए मैंने सिंघवी जी को कहा कि हाँ, मैं ज़रूर इस कार्यक्रम में आऊँगी, क्योंकि डॉक्टर सिंघवी, एल.एम. सिंघवी जी जो है, इनका जो एक योगदान रहा है, और यह योगदान एक धनी विद्वान, विधिवेत्ता, प्रतिष्ठित कानूनविद भी थे, संविधान के विशेषज्ञ थे। केवल इतना भी नहीं है, जिस तरीके से उन्होंने यूनाइटेड किंगडम में भारत के उच्चायुक्त के रूप में बहुत कुशलतापूर्वक कार्य किया, और मैं ये कहूँगी कि दोनों देशों के रिश्ते भी मजबूत करने की दृष्टि से भी उन्होंने अनेक बार महत्वपूर्ण पहल की है। अगर पार्लियामेंट की दृष्टि से सोचो तो संसद में अनेक ऐसी समितियों में उन्होंने महत्वपूर्ण काम किया है। या तो कभी कभी ऐसा लगेगा कि कौन सी समिति में उन्होंने काम नहीं किया, ये सोचना पड़ेगा, और उसमें उन्होंने महत्वपूर्ण योगदान दिया हुआ है। और ऐसे व्यक्ति की यादगार में कुछ कार्यक्रम हो रहा है, और ऐसे में इसमें अनेकानेक विषयों पर ज्ञानवर्धक एक प्रकार से व्याख्यान होते रहे, और आज का भी व्याख्यान इसी दृष्टि से महत्वपूर्ण था। वास्तव में होना ये चाहिए कि स्पीकर is supposed not to speak. लेकिन मेरे लिए मैं आज थोड़ा सा, इसलिए मन की बात, मैं कोई बहुत विद्वान तो नहीं हूँ, इस विषय पर विद्वत्तापूर्ण बोलूँगी ऐसा भी दावा नहीं कर सकती हूँ, लेकिन सामान्य लोगों की प्रतिनिधि हूँ मैं। और आज इतने साल से, जैसे आपने भी ताली बजाई कि 8-8 बार मैं चुनाव जीत करके आई सामान्य लोगों का प्रतिनिधित्व करते हुए, और आज एक ऐसे मुकाम पर पहुंच गई हूं, एक तो महिला होने के नाते भी होता है कि आज ऐसी मेरी स्थिति हो गई है कि मेरे क्षेत्र में भी और विभिन्न क्षेत्र में काम करने वाले लोगों को भी लगता है कि आप एक अब माँ जैसी हो गई हो, और इसलिए माँ ने हर एक का दुख सुख समझना चाहिए और सही जगह पे उसको व्यक्त भी करना चाहिए। हमारी बात को आप थोड़ा आवाज़ दो, आपने वो समझना चाहिए, ऐसी एक एक्सपेक्टेशन मुझसे होने लगी है। तो मैंने सोचा वहाँ तो मैं ज़्यादा नहीं बोल सकती, ये भी बात कहूँगी कि मैं आदरणीय दीपक जी के भी भाषण पे कमेंट, आई जस्ट कांट, आई शुड नॉट, आई नो इट, लेकिन मेरे मन के भाव मैं कुछ व्यक्त करना चाहूँगी। फ्रेंड्स, in a vibrant democracy like ours, the judiciary is an important pillar of the state, like the legislature and the executive are, with its distinctive role and functions. Our judiciary, especially the higher judiciary, has been assigned a position of vital importance and bestowed with onerous responsibilities like upholding the constitutional principles, interpretation of the laws made by respective legislatures, and more importantly, in protecting the fundamental rights of our citizens. The Supreme Court of India and the High Courts act as the final arbiters of constitutional disputes and can overrule not merely ordinary law enacted by a legislature that enjoys popular will, but also constitutional amendments, which in the court's view infract the basic structure of the Constitution. With a proactive role based on the power of judicial review, the higher judiciary in India has attained an unprecedented significance. The institutional integrity of the judiciary, therefore, requires the courts to enjoy the confidence of public. Society needs to see judges as protectors of justice, who will stay independent to uphold the people's most fundamental rights. A strong ambivalence clouds the public image of the Indian judiciary. They are simultaneously fountains of justice and beyond the reach of poor. Litigation is often regarded as infested with delay and not free from corruption. But courts, especially higher courts, are among the most respected and trusted institutions. The judiciary has ensured that howsoever high you may otherwise be, the law is above you. On the other hand, symptoms of inefficiency haunt the courts as they do other state institutions. This mixed picture is reinforced by a recent assessment of a high-ranking expert group, including a former Chief Justice of the Indian Supreme Court. Widespread and profound backlog and delay currently undermine the fundamental priorities of a law-based society, and it erodes public trust and confidence in legal institutions, and also acts as a significant barrier to India's chosen path to social justice and economic development. While it is acknowledged that trials are delayed throughout the world, but nowhere, however, does backlog and delay appear to be accentuated than in modern day India. As well as we all know, justice delayed is justice denied. Since all the organs of the government are independent, and at the same time, there is a relationship between all the organs, it is the job and combined responsibility of the Parliament, the executive, and the judiciary to address all these issues. And I would therefore like to emphasize that judicial reforms are must. The calls for judicial reforms are, of course, in the unveil for quite some time now, and a lot has been done in this regard. However, it cannot be denied that a lot still needs to be done. The Law Commission's recommendations concerning disposal method, appointment of judges, creation of special courts, need for system-wide reform merits serious consideration and action. We have to remember that we are among the fastest growing economic, and when efforts are made to fast track all aspects of government functioning, the judiciary cannot lag behind. It is important that justice delivery system has to be fast tracked too. Among others, we could think in terms of instituting alternate dispute redressal system, lok adalats, yes, specialized courts, mediators, etc., to ease or reduce the pressure on courts. We have to think and act in terms of filling up the vacancies of posts for judges in the judiciary, which is one of the reasons for delay in dispensing justice, yes. However, the increase in number of judges has to be calibrated carefully to ensure that quality does not get compromised in this process. We need to make optimum use of technology, systematic classification of cases, comprehensive tracking of ongoing proceedings, and similar measures. We also need to take steps to make careers in our judiciary more attractive to attract the young talents in our country. अब एक बात ये भी आती है, कुछ एक सजेशंस, मैं इसलिए ये सब बातें बोल रही हूँ, थोड़ा धाड़स करके बोल रही हूँ, आई नो इट, मगर यहाँ पूर्वज भी कई बैठे हैं और ये होता है, नाउ दे कैन थिंक फ्रीली, और जो वर्तमान में हैं उनके साथ डिस्कस करेंगे, जो कई सारे ऐसे इस संदर्भ में सोचने वाले लोग हैं, लेट अस थिंक फ्रीली, दैट इज़ व्हाट ओनली आई वांट टू से। तो न्यायाधीशों की कमी को पूरा करने हेतु वर्तमान में प्रतिनियुक्ति पर भेजे गए न्यायाधीशों को वापस बुलाकर क्या न्यायपालिका की मुख्य धारा में लाया जा सकता है। आई एम गिविंग ओनली सजेशंस, आई एम नॉट सजेस्टिंग एनीथिंग, बट इट इज़ वी मस्ट थिंक अबाउट इट एंड हाउ टू। न्यायाधीश न्याय प्रदान करने के लिए नियुक्त होते हैं, उनसे अन्य प्रशासनिक कार्य, अब ये मैं बिल्कुल छोटे कोर्ट से, क्योंकि मैं तो छोटी जगह से आती हूँ, मुझे सुप्रीम कोर्ट की बात नहीं मैं ज़्यादा कर सकती, मैं छोटे न्यायालयों की भी बात कर रही हूँ, कि उनसे अन्य प्रशासनिक कार्य जैसे अकाउंट्स, मालखाना, नकल, दफ्तर आदि की देखरेख का भार नहीं डाला जाना चाहिए। स्वतंत्र न्यायिक प्रशासन सेवा जुडिशियल एडमिनिस्ट्रेटिव सर्विस निर्मित कर इस काम में न्यायाधीशों की ऊर्जा का अपव्यय रोका जा सकता है। ऐसे सभी पदों पर जिन पर कार्यरत न्यायाधीशों की नियुक्ति अनिवार्य नहीं है, कार्यरत न्यायाधीशों की नियुक्ति ना हो, इस पर चिंतन करना चाहिए। जैसे श्रम न्यायालय हो, परिवार न्यायालय हो, विधि सचिव, विधानसभा सचिव में भी मैं देखती हूँ, शासन के अन्य विभागों में भी विधि सलाहकार होते हैं। ऐसे अनेक जगह है जो मेरे देखने में आती है। यू हैव टू थिंक अबाउट इट। विधिक सहायता व लोक अदालत का कार्य भी सेवानिवृत्त न्यायाधीशों अथवा वरिष्ठ अभिभाषकों को दिए जाने पर विचार किया जा सकता है, ताकि इस कार्य में कार्यरत न्यायाधीशों का समय तथा ऊर्जा का क्षय ना हो। The statement, a lawyer is and must ever be the high priest at the shrine of justice, captures the essence of the role of an advocate in the administration of justice in the society. Lawyers in our country, अभी एक कुछ बात कही गई, मुझे नहीं मालूम नारद किसे कहा गया, नारद की भूमिका, मैं अभी उस पर कमेंट नहीं करूँगी। Lawyers in our country have historically contributed handsomely to each of these areas of justice, whether it was the struggle for independence, the framing of our constitution, or just governance. The role of lawyers extends to being an integral part of our system of administration of justice, not just in the legal sense, but justice that is social, economic, and political as set out in the preamble of our Constitution. They are also expected to play their assigned role in realization of the lofty vision of speedy justice for all enshrined in our Constitution. We must also discuss and debate whether the unrestricted entry in the bar has led to deterioration in the quality and standard of lawyers, and whether it is affecting the quality and standard of entire judicial system. ये भी एक विचार करने लायक बात है। मैं ये सब इसलिए बोल रही हूँ, एक बार एक बहुत बड़े हमारे यहाँ के वकील जो जाने माने थे, सोली सोराबजी जी, मैं कहना चाहूँगी वो इंदौर के थे, इसलिए हो सकता है ऑल इंडिया लेवल पे उनका नाम नहीं हुआ हो, पर सालों साल के बहुत जाने माने हो। एक बार उन्होंने एक कमेंट करी थी कि आजकल कोर्ट में जाने का मन नहीं करता। मैंने कहा क्यों ऐसा? उतना ही कहा उन्होंने कि ऐसे वकील भी आए हैं, कुछ समझना नहीं चाहते, और बोले कई बार सुमित्रा ऐसे भी होता है कि जिसके सामने मैं आर्ग्यू कर रहा हूँ वो ऊपर बैठा हुआ व्यक्ति समझ रहा है कि नहीं, ये भी मुझे डाउट होता है। आई एम सॉरी, आई एम नॉट, मैं किसी पे कमेंट नहीं। एक सिंसियर जो बहुत सीनियर एडवोकेट, जाने माने एडवोकेट, और ऐसे व्यक्ति ने ये घर पे बैठे बैठे मुझसे बात करी, और इसलिए मैं वो दर्द थोड़ा सा चाहूँगी वो आपके सामने मैंने रखा है। I would also like to mention that the Parliament of India has also taken initiatives to address this challenge. Though the National Judicial Appointments Commission Act 2014 has been struck down by the Honorable Supreme Court, let us hope that in the near future the issue will get resolved with the cooperation of all concerned and to the satisfaction of all. Justice Krishna Iyer said, and I quote, "Most crucial for justice, social, economic, and political for the happiness, health, and humanism of the people and their peaceful progress is the judiciary. We need a dynamic, people-oriented, progressive, legally literate, and imaginative judicature with a Swaraj vision. Otherwise, chaos will corrupt, confuse, and terrorize the Indian cosmos." I also feel that the best way to bring about the elimination of perceived shortcomings of any organ of our vibrant democracy, which are capable of being eliminated, is to have all our citizens informed as to how that system functions. Please think about it. Friends, it is important for our country to have a fast justice delivery system so that the image of the judiciary is enhanced and the people who knock the door of justice feel that they are heard and justice is delivered. If these challenges are not addressed, and if far-reaching judicial reforms are not initiated with a great sense of urgency and devotion, the image of the judiciary may be eroded. I'm sorry, आज जो हम पत्थर खा रहे राजनीतिक लोग, हम तो खाते ही आए, खा ही रहे हैं. So, the image of the judiciary may be eroded in the eyes of the public, thereby endangering the whole civil society and our democracy. In other words, timely disposal of cases is essential for maintaining the rule of law and providing access to justice, which is a guaranteed fundamental right. I would once again thank you for inviting me, and I am sure the views expressed in this lecture will go a long way in strengthening our democratic polity. एक बात और भी कहना चाहूँ, हो सकता है मैंने कुछ ज़्यादा कम कहा हो, मगर आप यूँ समझिए कि एक सामान्य, क्योंकि जैसा मेरा परिचय दिया गया, एक सामान्य कॉरपोरेटर से मैं यहाँ तक पहुँची हूँ, और इतने साल लोगों के साथ जो एक रिश्ता जुड़ गया, नाता जुड़ गया सभी प्रकार के लोगों के साथ, उसमें बात करते करते कुछ बातें, और कुछ हमारे यंगस्टर्स यहाँ सामने बैठे हुए हैं, मैं उनकी भी एक मानसिकता जो देखती रहती हूँ कि सॉरी थोड़े ज़्यादा बोल रही हूँ. एक बार एक कॉलेज में दीक्षांत समारोह में लॉ कॉलेज में गई थी, वहाँ भी मैंने देखा 5 साल बाद जब LLB बनने के बाद हमारे जो युवा है वो कॉरपोरेट सेक्टर में ज़्यादा जाना चाहते हैं, है ना. पैकेज हैज़ बिकम मोर इम्पॉर्टेंट. वो नहीं चाहेंगे कि मैं जाकर के केसेस लड़ूँ. वाई नॉट, आई जस्ट डोंट नो, बट सो मेनी थिंग्स आर हैपनिंग. और उसके कई सारे कारण हैं जो मैंने अभी बताए, ये भी हो सकते हैं. और इसलिए थोड़ा सा हम सभी लोगों को आज की जो हमारी पोजीशन है उसमें सोचना पड़ेगा, कहीं ना कहीं डिसीजन लेना पड़ेगा, एक बोल्ड डिसीजन लेना भी पड़ेगा, बोल्डली सोचना पड़ेगा. क्योंकि मेरी ये मान्यता है, जैसे माननीय अटल जी ने कहा, ये तो होगा, बाधाएं आती है, आए, घिरे प्रलय की घोर घटाए, पाँव के नीचे अंगारे, सिर पर बरसे यदि ज्वालाएं, निज हाथों से हंसते हंसते आग लगाकर जलना होगा, लेकिन कदम मिलाकर चलना होगा, कदम मिलाकर चलना होगा. तो मैं धन्यवाद देती हूँ कि आपने मुझे याद किया. धन्यवाद.
Thank you very much, Madam Speaker, for that inspiring and indeed thoughtful set of reflections. I must say that for many of us who have watched you in the Parliament, we rarely had the opportunity to hear you, but even both within the Parliament and outside the Parliament, you have spoken with humility, grace, and a sense of equanimity, and I'm indeed grateful to you for that. Now I call upon Mr. Avishek Singhvi, Advocate, Supreme Court of India, to propose the vote of thanks.
Srimati Sumitra Mahajan, Honorable Speaker, Lok Sabha, Honorable Mr. Justice Dipak Misra, Judge, Supreme Court of India, Mr. Soli Sorabjee, former Attorney General of India, Professor C. Rajkumar, Vice Chancellor, Jindal University, former Chief Justices of India, and distinguished judges sitting and retired, and esteemed members of this august gathering. I am truly at a loss of words as I rise to thank this most distinguished panel and very special gathering. I am truly overwhelmed, firstly with fond and everlasting memories of my Dada, and who even when he had no time, always had time for me. Secondly, for the warmth and affection you have all shown in turning up in such large numbers. The Honorable Speaker Sahiba found time to spare on the eve of Lok Sabha winter session, despite several other official commitments on Guru Nanak Divas. Madam, your life is an inspiration to all young minds who constantly wonder what degree of hard work and persistence it entails to carve out this unique niche that you enjoy today. Some of us would like to hear and learn from you at a separate lecture what you consider to be your guiding values and principles in your illustrious career. Certainly, broad-mindedness and inclusiveness, which has been alluded to, must be an important characteristic. I have had the privilege of seeing Justice Misra in court, and I am struck by his even-handed manner of dealing with all advocates, junior and senior, with unperturbed concentration and composure to deliver complete justice in each and every case before him. It is grossly underestimated as to how much this matters to the younger members of the bar and how much of an impact it can have for the growth and development of the younger bar. We have always been enlightened and enriched in his court, whether as silent spectators or as occasional participants. The younger bar also looks forward to the reforms for progressive orientation as elaborated by Justice Misra, because above all, our stake in them is the highest. Thank you, Honorable Sir, for your time and for reaching out to all of us in your most informative and illuminating address. Mr. Sorabjee is an icon for any member of the bar who has read landmark cases argued by him, especially in public law. As citizens of this country, we owe him a special tribute for being an active defender of some of the basic rights we take for granted today. I am in deep admiration of his crafty arguments to develop the right to travel or the right to movement, which forms part of personal liberty, as guaranteed in Article 21 in the famous Satwant Singh Sahani's case, and how finesse and fullness was imparted to it later in Maneka Gandhi. Sir, we can only hear and read about your legal exploits and several milestones you established, not only for yourself but for our country. It inspires the younger generation to remotely try and emulate you. I want to thank Vice Chancellor Kumar, who has in a very short time made Jindal University a global force to reckon with. That is clearly because of his indefatigable energy and his obvious dynamism. He is a rare academic who combines his academic distinctions with instant decision-making and accelerated execution. For there is an onerous responsibility on institutions like Jindal to produce fresh legal talent for our future generation of lawyers to be as bright as the past luminaries. Let me end by reading to you another part of Mr. Gopal Krishna Gandhi's article about my grandfather, which my father earlier read, and Justice Misra referred to it in his speech. And I quote, "Chagla was Chagla, Palkiwala was Palkiwala, Singhvi was Singhvi. They are not to be compared to each other, yet they had this in common. Whether as lawyers, ministers, or ambassadors, they thought for, spoke, and worked for the Republic of India. Leaders of shards, segments, and scraps stand tall today. Those who think of, speak for the Republic as a whole, stand to a side." And pondering that, it seems incredible that one like L.M. Singhvi was around till just the other day. For a man of so many parts, I remember him as the most loving grandparent one can ever imagine or dream for. A man who allowed me to take unspeakable liberties with him and who always took my side without fail. We miss you dearly, Dada. Thank you very much.
Thank you very much, and this program is ended. I want to apologize for those of you who stood through the lecture and heard it. I'm sure it's all worth it. Thank you very much.